Now, the data analysis for your book concluded in 2020, right? And as we all know, the world went through a few significant changes since then. And the court system in India has also had to evolve and adapt to the same. There's more automated listing. There's some high courts have adopted machine scrutiny to make sure there are no defects in petitions before listing them. And there's also live streaming. How do you see these changes impacting the way courts function in the future? And how do you think these changes will be reflected in the data regarding all the concerns that you've raised in the book?
So maybe I can get started on that. There have been, because of force of circumstances, some great innovations in how the courts work, not just the Supreme Court, but as you mentioned, the other courts as well. More accessible because there's live streaming of proceedings happening, definitely at the Supreme Court with constitutional benches, but other courts as well on more routine matters, which has opened the courts, I think, to another level of scrutiny. We've seen that play out in, video clips going viral, and the Chief Justice raising the concern that we need to rethink our court practices and very feudal court practices, because there's greater scrutiny and there's greater availability of sort of, the paraphernalia for that kind of scrutiny of court. So that's all good. And there is, of course, the ability of hybrid sort of hearings, which makes, again, the court more accessible to litigants and lawyers from other parts of the country. And that may have some impact. It's too early to know, but over time may impact the power that the small cabal of senior advocates wield in the Supreme Court, because then you're hearing more and more voices from all over the country. But we'll see how that plays out. There is an element that we don't scrutinize in our book, which is the advocate on record system, which is really the Supreme Court sort of way of gatekeeping lawyers who get into the who get to file in the courts, and that might still have a moderating effect on how much diversity there is in the sort of legal pool at the court. The automation can be useful, but with a caution that automation can also hide behind what might seem objective and neutral sort of machine processes. There might be biases that are encoded. So without knowing how these processes are working, I don't think it's enough for us to know whether they're working well. So they might be more labor efficient, well, time efficient in terms of removing the need for human scrutiny, but they might create their own problems. And one of the things that we figured out through working on this project and more generally is that without looking at the evidence, we shouldn't necessarily praise the court, as has been the norm for the longest time, or for that matter, criticize the court for its working. Again, as something that we've learned, there might be good reason for why the court is doing what it is doing. So there have been, I think, overall then positive changes. Some things that could have changed that have not is one of the big emphasis that the Indian courts have had is on oral advocacy, and there's might be a lot of reasons for why that has been the case. Here was a chance to move to documentary practices, but my sense is that while in some cases, such as in constitution benches, there is now, this element of having some structure, some time limits, more of a focus on documentary practices, that's not really percolated to every other case, and definitely not the case in other courts. So there is that element still of where courts could save up on a lot of time to rethink how they sort of process cases, and whether each case requires, that kind of an extended hearing. Everything that the lawyer wants to say has to be said orally rather than in a written form. And that will, of course, require both a change in court culture, legal culture, but that's perhaps the direction in which courts may have to move if they want to be able to sort of do justice in its various forms to the large number of cases that are coming up before the courts.
Right. Anything to add to that?
I'll just add that there's another sense in which I think the development of technology in this space is very important, and it really just builds on what Aparna just said, which is when we started this book quite a few years ago now, started working on the collecting the data sets that would eventually become this book quite a while ago now. There was so little in the way of databases, in the way of evidence-based research on the Supreme Court of India and the courts of India in general. That has changed dramatically over the last 8 or 9 years since we really began. And there are now many databases and very sophisticated work being done to create more data and to analyze the data that's being put together by many groups. And this is a very exciting development that is to be applauded for their ability to contribute to the understanding of all of these changes due to technology and circumstances, of course, over the last several years. And it really is the presence of more data, the presence of better means to collect and analyze data that are going to allow us to answer questions like the questions that you're asking us about how have the latest developments affected the courts. And I think the key takeaway here is it's just essential to continue to collect and continue to look to that kind of data, that kind of empirically informed research to ultimately make judgments about the role of, for example, hybrid hearings or the role of AI in screening filings, for example.
Right. Anything to add, Sital?
So I would just say the streaming of hearings can be a very valuable tool in many ways. In the research that I've done on the court, separate from what's in this book, looking at specific cases, much of the work of the court is not done in written form. And these hearings are not what happens in these hearings. For example, the judges might say to the government, do this, go do that, go do this, right? So a lot of decisions are being made at these hearings that aren't currently documented. It's just sort of listed as a hearing and things are not noted. So unless you're, and the information, the research I was doing, how I found out what was happening at these hearings would be a reporter who's written about it. And then that was the only documentation. But to the extent more and more, I mean, there should be more and more transcripts available as well. But to the extent it's widely publicized and people can actually understand that when these subtle decisions are being made without judgments being ever issued.
Right. I think it's also made our jobs as legal journalists and legal reporters a lot easier. Earlier, we used to have to go to court, and if there's only one reporter, we'd have to run between courts. Now we can actually report live in a more accurate manner, in a manner that the general public, people who are not lawyers, will actually understand